A very good day to you, ladies and gentlemen. Welcome to another episode of the Candy Talk here on Herman Manyora's YouTube channel. Remember, this is Kenya's most comprehensive political and public governance analysis show, where we bring you up-to-date comprehensive analysis of all that is taking place in this country and across the borders. We am here with Wakili Willis Otieno, who is the deputy party leader of Sabina party and a constitutional lawyer as well. Wakili, good morning.
Good morning.
How are you? I'm okay.
Yes.
I want us to look at what is happening here and then maybe get to understand some of these things in details. One, in the first place, we are waiting for, we are here still waiting for the court's verdict on the appeal that was made, or rather the petition that was made by the side allied to the state, of course, who wants those conservatory orders that were actually placed to on the assumption office of the deputy president nominee Kithure Kindiki to be lifted. We are waiting for that. But then, as we stand here, something caught my attention last week. The lawyers of the deputy president, of course, Rigathi Gachagua, were trying to do all their best to ensure that the judges who are impaneled by the DCJ actually get to recuse themselves. And I think the judges were adamant. What do you think these lawyers are actually trying to arrive at? What were they going to benefit from their apparent request for recusal by these judges?
You know, part of it may have been delaying tactic. You don't want the court case to start. You allow tempers to cool down. Yes. And you don't want things to be rushed. And the speed at which the state had been moving this issue of Gachagua's impeachment, you don't want to quickly go back to court when tempers are still up and the feeling is still hot. So you try to delay the start of the trial, and you hope that will, by the time you go to the actual trial hearing, things have sobered up and you're able to now prosecute your case. So I believe that was part of their tactic. Because if you look at the grounds that they raised for the judges to recuse themselves, in my view, in as much as there was substance, but it was not substance that will merit a recusal. But they got their 2 days arguing those two applications. And also it put the judges in a very difficult position, because having been discussed for 2 days on the handling of the matter, they subconsciously became parties to the dispute. Because even them, they've been attacked.
Right.
Issues have been raised about them. So your natural instinct, being a human being, judges don't come from heaven, they live here on earth. You feel that you are being attacked, so you take a defensive approach.
Okay.
So they are allowed to struggle with that subconscious attitude when they go to the hearing of the case. Okay. Because if they don't succeed in dissociating their individual human feelings to the dispute at hand, then Gachagua's lawyers will have a field day with the proceedings and even on appeal. So that was more of a trial. And I mean, I like the counsel which Amino said, that sometimes when you're asked to recuse yourself, it may not even be that there's substance in the allegation being raised, but it is more in the perception. When one party has taken a very strong stance against you, and you have these proceedings which is attracting national interest and is beamed live on TV and online, why would you want to insist on being that when other judges can hear it?
But is it in order for the judges to recuse themselves based on just perception?
Yeah, many times, in fact, judges many times recuse themselves from hearing matters, not even because of substance. I've had cases where a judge recused himself just because she went to school with my client. Yeah, and they're not even friends in school. She just felt that because of the fact they were sitting in the same class for long, she didn't feel comfortable to hear the case. And it's understandable. So there's nothing untoward about it.
So there would be some sort of conflict of interest somewhere in between?
No, just the perception. She didn't feel comfortable handling her her classmate's case. And it happens. And we very well understood that that is something that can happen. And because when it comes to the question of justice being done, it must not just be done, it must be seen to be done. It's perception. The question of independence of or impartiality of the bench is more of perception than reality. There may be no substance in the allegations against you.
Okay.
But the perception that is created out there is what determines if people are going to have confidence in the judicial process or not. So if that perception continues, it permeates, then it undermines the authority of the courts.
Okay.
And that is why I say sometimes judges recuse themselves. Not for even, you don't even have to give any reason. Just feel, can even just say, I don't feel comfortable. The judge may even meet you in a supermarket when he's hearing your case. And the next time you go before the judge and he says, I don't feel comfortable. Because we're in the supermarket all haggling over viazi in the same corridor.
Okay.
So he feels, no, I mean, having been so closely in close contact with one of the parties, I don't feel comfortable. And that is allowed. It's permissible.
Okay. But do the lawyers, okay, when they put their request, and of course that request was put to the to the Chief Justice to empanel a bench, do they have to direct on who and who should?
No. In terms of who should hear the case, it's not upon parties to direct.
Okay.
That is the system that will determine. And for the empanelment of the three-judge bench, that is the role of the Chief Justice. And the Chief Justice, in our wisdom, chose the three. And the three are in their own right.
Remember, there was also a conflict of whether of it being done by the district.
No, the first step was that, you see, the first empanelment, there were the initial petitions, which had been empaneled properly by the Chief Justice. The only question that was being canvassed was the empanelment in relation to the file of Kirinyaga.
Okay.
Already these judges had been empaneled to hear the other 20 petitions in relation to the impeachment of Gachagua.
Okay.
So what the DCJ did was just to send the Kirinyaga file direct to the same bench that in any event was handling that matter. In fact, if you asked me, the neater way it would have been for the Kirinyaga judge not even to send the file to the Chief Justice. The Kirinyaga judge should have sent that file to the bench in Nairobi to deal with it, so that we don't have to deal with this question of empanelment, because that raised an issue of why is the DCJ purporting to perform a function of the Chief Justice, which it should not, especially when the Chief Justice is available. But sometimes it happens that you have a matter before a court. There's another similar matter before another court. And the court can say, I transfer this file to... So then it becomes a question of empanelment. Just say that there are similar issues in this particular case. I'm transferring this file to that other court. So the court in Kirinyaga, in my view, instead of sending the file to the Chief Justice, should have simply transferred the file straight to the bench that had already been constituted by the Chief Justice, because they already had active cases in relation to the same subject matter that they were handling it. They were handling. So you should have just sent it to them.
How are these delaying tactics maybe going to help the advocates of the deputy president?
As I told you, number one, it brings people back. Time is a master healer. It reduces tensions, tempers. The heat goes down. Then you have an opportunity to argue your case when now the heat of the moment has come down. So that is it helps in that particular way. Another way is that for Gachagua, for one day that is still hanging on there, hanging on that thread, he thinks he has life. So it's another day.
Do you think he has life?
No, Gachagua doesn't have life. Because politically, he's been impeached. The only question that are being canvassed are the legal process that was adopted to impeach him. But politically, the system that he used to serve gleefully has impeached him. So I don't think he has any political life.
In your view, do you see the courts lifting those particular orders?
Even, I do not want to speculate on what the courts will decide. But I hold the view that just from a bystander observation point, there were several infractions on Gachagua's rights, especially in relation to the conduct of the National Assembly and the Senate. The National Assembly, when they were debating the motion, they brought extraneous facts which didn't constitute the substance of the motion to inform the debate. Then the Senate, also having failed to constitute a special committee, when they decided to convert themselves to be the special committee of the House, they never came up with a report. And it is upon that report that they ought to have invited Gachagua to appear to respond to a finding of that report, whether he should be impeached. The right to be heard, to be present, to be heard, and to be represented by an advocate. They didn't do that. The Senate was very in a hurry to impeach.
So this
to
plenary...
include that they even ended up denying him the right to a hearing. Those are questions which the courts will have to
Okay, and of course, there are certain people who are giving, now that it was sitting in plenary, then maybe they shouldn't have had a report presented here.
But that's a wrong approach. Because what the Senate is supposed to do, once it receives an impeachment motion, it's supposed to investigate. So when did they do the investigations?
Okay.
So if they're doing the investigations as a plenary, they should have done that investigations. At the end of the investigations, write a report. And the report tells us this committee of the whole House has resolved to impeach Gachagua. The committee
Of the whole House.
so it is the committee report that is voted on. Then you say the report is tabled, then the House votes whether to adopt the report or to reject it. Okay. But what they did, they purported to conduct a trial, then invited senators to vote at the end of the purported trial, to vote on each of the counts.
Okay.
Impeachment is a report. It tends to the report because even if you have to go to court, you want to look at the grounds of impeachment, the evidence that was adduced, Gachagua's response. If the other witnesses who came, what are the witness testimonies? And the report says what are the Senate's findings. But now, where are the findings? And the finding is the vote of 46 against 14. That's nonsense. These senators are eating our money for nothing. They don't even understand how to conduct an impeachment. And the Constitution is very clear. An impeachment is an inquiry. You conduct an investigation and you come up with a report. The report will have evidence that persuaded you to recommend an impeachment. And it should be a very voluminous document setting out your response to each of those allegations, the evidence that informed. Not just telling us 14 voted to impeach, 49 voted to impeach, 14 voted no. What informed them?
Okay.
Without the report, we lose that opportunity.
Now, let's get to, because the deputy president, by the way, I'm getting confused here, how to refer to Rigathi Gachagua. The deputy president.
Deputy president.
Now that nobody has been sworn in yet.
Impeached deputy president.
Impeached deputy president is here. You're saying that he's done. Politically, if you look at this thing, leaving alone all the legal hurdles within, it seems like the ground is shifting. Some of the leaders, especially from the Mount Kenya backyard, and those who've been seen to be on the other side of the political divide, are actually finding it as kind of difficult even addressing and talking to their people, hearing. But at the same time, you hear saying, Gachagua is done. So I mean, why would people react to them in such a manner?
People are not reacting to Gachagua. People are not reacting in Mount Kenya because of Gachagua. Kenyans went to the streets and Gachagua was defending Ruto. Even in Mount Kenya counties, people are demonstrating.
Okay.
The mood in Mount Kenya is not about Gachagua. The mood in Mount Kenya is about the failed economic policies of William Ruto and Kenya Kwanza. So no one should lie to you that Mount Kenya people are on the street, are angry because of Gachagua's impeachment. Otherwise, as one hawker put it, while Gachagua was in court fighting for survival, Kikuyu hawkers were selling outside. They didn't care about Gachagua's impeachment. They were selling their wares. And they are struggling to even get customers. So don't read the mood in Mount Kenya or even in Nyanza or even in Coast, the disenfranchisement with the administration, to be about that we are reacting because of Gachagua. No. Kenyans are angry because William Ruto and Kenya Kwanza have failed on the economy.
So here, we are having here a national holiday, or rather function. Somebody comes to read the presidential speech, and then all of a sudden people start booing. We didn't see that happen elsewhere, but it happened over there.
What?
Do we then?
Did you see people even attend meetings in Kisumu? Yeah.
They did.
They didn't. In Siaya, where were the celebrations in Siaya? There were only 20 people. Yeah. I mean, it was across the country.
Okay.
Kenyans don't care about William Ruto and his failed economic policies and his administration. We've moved on. Before, national holidays was a very auspicious day. And Kenyans will turn out in large numbers at their respective district headquarters to celebrate. Nowadays they don't. They don't even go to watch the band. If for nothing else, just for entertainment. They don't. Because they don't recognize this administration for the killings they've done. The forced disappearances, the abductions, the economic pain that we are going through. So don't try to turn it that it was because of Gachagua. No. Kenyans are rejecting William Ruto for William Ruto. William Ruto was rejected even when Gachagua was his deputy before he was impeached. So don't try to mix the two,
I was
please.
thinking maybe it's a ground shifting towards Gachagua's side.
Where, how? No, where? When Kenyans were burning parliament here, when we breached parliament, where was Gachagua? He was with Ruto in State House, calling us terrorists. We didn't go there because that he was impeached. So don't try to read the mood of the people.
But these failed economic policies of Kenya Kwanza didn't begin yesterday. They've been there before. But then initially, we didn't used to see such kind of...
Kenyans gave them 1 year. Now it's 2 years. And it's more pain. And more pain. Even a rubber band has an elastic limit. So Kenyans have the elastic limit. Maybe last year they could take it. Now it's becoming unbearable. And there's a promise of pain every year.
So the ground is becoming...
So it's elasticity, the rules of elasticity. Yeah. So the more pain, the more they are in power, the more they come up with these measures, the more pain we are feeling. And people start responding, people start reacting. It will snap.
So are they angry at the president or at his policies?
They are angry at both. He's the one who superintends over the policies. He's the one who comes to those policies. The policies don't find themselves on the table on their own. They don't get implemented on their own. He's the one who implements them. So they're angry at both of them.
Therefore, you're saying, do you listen to the ground, you personally?
I'm telling you, the Kenyan people, on the 25th of June, wrote on the wall, Mene, Mene, Tekel. William Ruto's time is done. That's what the ground said. And even if William Ruto, I'm telling you, Kini, were to build gold roads, gold tarmac roads to everybody's single home, was to take tapped water to everybody's single home in this country, Kenyans and him are done. He'll never recover. Never. That I assure you.
So the ground has shifted and has shifted completely.
And when Kenyans have branded you, there is no, in politics, at the national level, once you are branded, there's no recovery. We are done. We are looking for the future. You are the past. William Ruto is our past. Just occupying space, but he's our past.
Well, those are the words of Willis Otieno, the deputy party leader of Sabina party, and of course, very formidable deputy presidential candidate come 2027. We wish him all the best, and we are here. Let's wait and see how this journey will be for them. Ladies and gentlemen, thank you for tuning in. Till we have this conversation again, have yourself a lovely day. My name is Evans Okini.